All right. So, hello everyone, and welcome to That's Probably Not Legal, or is it? A lawyer.
It's a very negative way. I'll just immediately hijack this.
Oh, excellent.
When I went in to read, kid books to my then kindergarten daughter's class, and they asked, well, what do you do? And so I'm not only a lawyer, I actually teach law at the University of Richmond. And I immediately thought all the negative things lawyers do. I gum stuff up. I'm the one who says no. I'm the one that makes projects too costly. I'm the complete shatterer of dreams. I completely, and I said, no, we're facilitators. Yeah. We make things happen. I know you guys might not, if you've run into us, you might not think that's the case. So I want to put a so it's not saying a lawyer is what you can't do. We'll tell you what you can do. It might not be what you immediately want to do.
Right. But if you end up changing your mind later and decide that you do want to do it, we can help with it.
Sorry, I didn't mean to hijack.
It's okay. It's okay. It's fine. So, yes.
I do, though, describe myself as a professional parade rainer. So.
Oh, my God.
See, okay, I'm the only happy one of the bunch. If you want to get something done, chat with me.
I'm incredibly happy. So, but anyway, so welcome to the lawyer panel.
I stay with a smile, though.
Here. I will say, you can't see that right now.
No, I'm telling you.
So one thing we want to kick off this panel with, I don't know if you can tell, we're all very energetic, which, we're lawyers, so that's weird. But we want to kick this off and say anything that we're saying today is for informational purposes only. This should not be construed as legal advice. Literally just information. We are not your lawyers yet, except for you. I'm literally your lawyer. But we're not your lawyers yet. We are available if you need it. However, this does not create an attorney-client relationship. If you have questions, which actually this is an AMA, so I hope to God you have questions.
Please.
Then please make sure that it's not like a specific, well, I shot somebody. Is that illegal?
Okay, don't confess to anything.
One, yes, that's illegal. And two, if your question's a little too specific, we might have to say, talk to me later kind of thing.
The answer is hire a lawyer.
Yeah, hire a lawyer. And there's at least 3 up here. So, but without further ado, I'm going to quickly let us introduce ourselves. Sam, if you want to go first.
Sure. My name is Sam Castry. I'm the head of entertainment law at Crawford Intellectual Property Law. We're a little IP firm in the Chicago suburbs. I work with a lot of indie game developers. I have some Twitch, YouTube streamers as clients, musicians, and sort of other stuff, whatever else comes in the door sometimes. But I've probably seen a lot of the issues you might have questions about. I hope.
Yeah. And my name's Noah Downs. I'm a lawyer like these guys, but we're all cool lawyers. You can find me on Twitch, Twitter, and TikTok at My Lawyer Friend. I'm the senior counsel at Premac Rogers PC, which is a game development firm. And some of our clients include Atari, Telltale Games, Tiny Build, Versus Evil on the developer and publisher side. And on the broadcaster side, we represent entities such as Co-Carnage, Sacriel, and several other larger streamers as well. So between, at least the 2 of us, we've seen it.
If you want to find me on Twitter, Indie Game Lawyer, INDIE. Independent, not like from Indianapolis.
And
Indie games.
I'm Chris Katropia. I wanted a reason to go to MAGFest, and so that's why I'm
I put
here,
him on a
quite
panel.
frankly. But I'm a law professor. I've taught intellectual property law since 2003. I also do practice mainly patent law. So our clients have a small firm in Richmond. We don't do a lot of indie game developers, but I like playing indie games, and so I'm a law professor, so I'm happy to act like I know an answer to any question. I'm glad to be here.
And he's also was my law professor in law school, which is why he's here. So clap for Professor Stropia.
Yay!
That's
awesome. So we have something. Hey, listen, I graduated a
That's
while
right.
ago.
I can't affect his grades now.
Yeah, I mean, can you?
No, that's a statute of limitations, right? We can start our law talk now,
with
right?
a statute of limitations, G&A. So we have things to talk about in case you guys don't. But want to go ahead and open it up and you start off with some questions. And if you run out of questions, we're just going to start talking.
We can do that for a while.
Yeah. Guy in the green.
So very first, basically, most of the people here are either contributors or creators of small indie games who do not have large budgets.
Right.
Right. So what are the very basics? You say you won't give us advice, but the very basics that we should know to not step in poo.
Yeah, so I'm going to repeat every question for the YouTube recording. Basically, the question is, most folks here are coming from the indie game perspective, people that have created their own solo studio or they're working with a group of folks. So what can folks do who don't have much budget what can people who don't have much budget do? There you go. To protect themselves, and what is kind of the basics that you need?
Actually, before we get any further, who is here in game development? Let's just quick survey the room.
Indie game development, raise your hands. People who are just interested in law, raise your hands.
Wow. Okay.
Do we have any other lawyers in the room?
Lawyers or law students?
Oh,
Yeah. Hey.
Cool.
Yeah, nice. Good.
okay. Yeah, paralegal, that counts.
Yeah.
Even more so. You
Excellent.
really actually do.
Did anybody here come just looking for a job at a law firm? Okay. Yeah. So to answer your question, what are some basic things to do? Well, I'll kick it off, basically.
Yeah, go for it.
As an indie studio, one of the things that you really want to make sure you do is protect your IP. Whatever that is. So if you're working by yourself or if you're working with other people, you want to make sure you're protecting your IP. And that is, if you haven't released your game, you have protectable trade secrets that you want to take care of. If you're going to be releasing a game, you might have a trademark that you need taken care of. If you're working with other people, you need a contract with those people, because contracts save friendships. I know contracts sound horrible, but if you have a contract, if things go south, then your game's not dead. So yeah, I would typically say the 5 things you need generally are to plan for a trademark, have an independent contractor agreement. Eventually, you'll need a privacy policy in terms of services. That's not immediate. And an NDA. And most people will say an LLC of some sort if you're United States based. So that's kind of where you start. What about you? What do you think?
Yeah, no, I think that's pretty much it. I usually people come to me, what do I do? Usually want to get the company set up first. There are different
that's the LLC, right?
Yeah.
So
LLC.
that's what I was going to ask about ordering here.
Yeah, that's right.
LLC is probably
Typically,
the
so
first-
someone comes to me, I got your name from so and so. I want to start. I'm working on this game. What do I do? So typically, you want to set the company up first. Usually an LLC, it's a lot easier. And in my home state of Illinois, they used to be way more expensive than corporations, but they're not now. So that's typically the way you want to go. There can be tax issues. I'm not an accountant. I don't know anything about tax law.
Yeah, me neither.
So talk to an accountant about that sort of stuff. But usually we do the LLC because it's easier and there are fewer hoops you have to jump through, less red tape, and fewer ways you can screw up and put your own house and car and bank account in line.
Yeah.
You don't want to do that. So we get that up. And that's also just an easy way to hold everything. All the different rights you're going to be dealing with. You're going to want definitely the independent contractor agreement. And if you're working with people, figure out what their relationship even is.
Yeah.
But first, are they business partners? Is it your buddy who is going to do you a solid and do some quick coding or a song or two for your game?
Is it a
figure it out.
fan who just literally sent you something like, I actually really like that?
Figure it out.
Right, because the concern is that other people are going to create things, and originally the ownership's going to be theirs, right? And even if they say to you, hey, I really want this music for your game. The way copyright law works is it needs to be in writing and signed over to you. And I see this even the number of times people screw up in not getting agreements, particularly if you're outsourcing your work, particularly in some, I've seen these it turns out the people I hired to do all the development, they own all the code or they own the website. That's not good.
You definitely need to get that. And especially for copyright stuff, it has to be in writing. Say, I give you this copyright. Unless it's your employee, which gets into a whole bunch of labor law issues you don't want to deal with, and I don't want to deal with.
Right.
So there's that.
I was going to say, just to piggyback on that, basically, if we take care of the contracts up front, it's going to save you a lot of money. It's much better for us to be proactive instead of reactive with this kind of stuff.
I make a lot more money fixing things afterwards.
LegalZoom is great for us.
You want that contractor agreement. You can just give it to people. And I can usually get like a more or less template. You can fill in things depending on what you're doing. We might need to kind of tweak it, but at least we have the basics to start from. And I need to rework this for my composer who is going to have some kind of streaming rights. Okay, at least we have the basic skeleton there. At least a trademark search. When you're ready to go public with your name, you should get a trademark search done to see what else is out there. Is this really close to somebody else? Should you abandon ship and get a new name? Because you do not want to have your Kickstarter and get all these social media stuff and everything going, and then 9 months later you get the cease and desist letter from somebody else. This is my trademark. I registered it, or I put my application like 2 years ago. I'm about to launch. You have to change your name now. That sucks. Don't be there. And you can even get your trademark application in. Intent to use application. You say, I'm not using this yet, but hold my place in line because I'm going to do it soon. Right. And basically you have between like 3 and 4 years, depending on timing, and buying extensions of more time to get your game launched and start using it. And then you file the paperwork, say, yeah, I'm using it now. Here it is, registered, mine. And it has happened on occasion that I have to file a new application because we run out of extensions we can buy. So there's always kind of the timing issue, when we want to apply, when we want to announce a name and go live and start advertising, publicizing ourselves, how long it's going to take, and how much can I afford to spend on buying these renewals over and over again. Yeah. But there it is. And just one more. The final piece is when you launch, copyright registration. Yeah. And we can get into that a little bit more, but
yeah, and there's no one size fits all, but it's really good to be thinking about it ahead of time. So no matter where you're at, it's always a good time to kind of have that chat. And one thing that I know is that most attorneys in the space, the ones that you want to work with, will offer a free consult to kind of get to know you a little bit better, see where you're at in the process, help you estimate costs if cost is a budgetary concern, which for most of us, we're very cognizant of that. So I know at least we offer a jumpstart package, so to speak, which like you can kind of package a bunch of things together. And I know that other places do that as well. So
yeah, I'm actually very lucky. I was able to when I graduated, I didn't have any kind of job prospects. Couldn't even find a place to give my time away. Like volunteer work. Yeah, it was bad timing. So I just kind of was hanging my own shingle, doing odd jobs here and there. Got hooked up with a couple indie game meetup groups, and kind of built a practice on that, and then found the woman who's now my boss, and kind of got to meld that into an actual law firm legal job. Mm-hmm. So I'm very lucky that I can offer people who don't have a lot of money drastically reduced prices because I know you don't have money. Mm-hmm. And all I ask is you go out, be wildly successful, and then I'll charge you real lawyer prices.
Yeah, make them on us. I saw you first, and then I'm going to have you next. So go ahead, bud.
So basically, to piggyback on what you just described, and I guess you can explain to the audience what I want to ask.
Mm-hmm.
What happens if you get suckered into a sucker contract or are a victim of patent trolling?
Yeah, so the question is, what if you get wrapped up in a bad contract, or you're the victim of patent trolling, which is
those
are two very different issues.
Yeah, very different.
So what do you mean by patent trolling? Either one of these fly-by-night invent help firms, or?
Well, basically they hold on to the patent and they never do anything with it until someone else does something similar, and then they go out and they technically go out from legally, and that's how they make the money off it.
I think somebody basically is sitting on a patent and trying to find somebody else.
So that does happen a lot. I mean, on the patent trolling side, I'll have to say, and we actually are trying to help a client with this right now. It can become very difficult because that's a very expensive space to play in. Typically, patenting can only become a problem for people that are kind of in high investment areas. So an indie game might come into the zone of a patent troll, but usually you need to get to a size in which the troll would care about.
And have something patentable too.
Well, I think what he's talking about is that somebody might have a patent on, let's say, a multiplayer game feature. Right. I'm going to pick something here. And they're sending out cease and desist letters to people who have a game that has a chat feature on it or something like that, maybe.
I'd add that actually someone found it is a great defensive tactic to be in a proactive move, where you have two parties and they know that they have patents of stuff the other party has, keep them hands off.
So it's true. I think patenting, one thing that you'll notice in the answer to this question is that patenting is normally not one of your kind of first things if you're an indie developer. Mm-hmm. It's a fairly although filing a provisional patent application, which is an early patent application, can be relatively inexpensive, $1,500. It's not really the best front end move if I'm a developer of a game. My gut is that your real secret sauce is the concept of the game. We're talking a lot about trademark here, so it's going to be about the brand. There are other Among Us games, but my daughters only play Among Us. Why? Because the brand is so strong, right? And so. But patenting can, if it turns out, one interesting thing when you go to the floor here is you see these amazing different kind of controllers.
Yep.
I mean, that's a space that I do think about. Wow, that's a really neat way to interface. That would be one where I think I probably would say to someone, hey, you know what? Let's file a provisional patent application on this because this might be something that other people would really like, this kind of controller. And you're right. If I'm going into a space where there are a lot of patents on controllers, which there are a lot of patents on controllers. I don't know if anyone knows the Scuff game controller. They are incredibly litigious on those quick trigger buttons underneath the controller. It is good to file patents in a sense of a defensive measure. So.
Go ahead. Yeah.
I'll just say, also, in terms of patents, though, if you're an indie game developer, you probably aren't even eligible for a patent. You probably don't have anything that's brand new, novel, or non-obvious, which is kind of a fuzzier standard. But like, but I mean, you probably aren't doing something that's completely brand new. No one's ever even thought of it or had the slightest idea of it before. It's probably something that's more iterative on what's come before, which is fine. Right. But means you're not going to get a patent on it, which is also fine.
Mm-hmm. Right. I think it's a question of whether you want to pay $1,500 to basically purchase an option that within a year, if it's going to become really popular, it might be worth doing. It would not be one of the top things. I would form your LLC first.
Yeah. And
it would be what I would do.
And to kind of answer the question generally as well, including the what if you get into a bad contract situation.
Yeah, that's a good.
One, don't sign a contract without an attorney reviewing it at all. And if you have already done so, and again, like I said, this is not specific advice, then talk to an attorney immediately because there could be circumstances that you surrounding the execution of a contract that or potentially illegal or perhaps it was a contract of adhesion or something like that. So make sure you speak to an attorney immediately. Don't try and navigate it yourself because quite frankly, you're just going to lose your boot to the mud, and then you'll have to buy new boots. So I just came up with that. I really like that analogy.
That's very good.
So make sure you talk to a lawyer.
Boots can be cheap. You might want to pick something a little more expensive than boots.
I don't know. Uggs paid Tom Brady a lot of money to promote them.
So. Okay, fair enough.
But yeah, so.
But on the other hand, if you sign a contract, the default assumption is you're stuck with that contract.
Yeah.
So all the more reason you should. Everybody read the contract. And I know, you like 10-page terms of use on whatever app you're about to download.
Or 80-page if it's Apple.
You're right. All right, and you scroll, I don't care, click I agree. And we've done that too, better or worse.
But I think it's smart, though. You're using, you're going to use Unity or something. I would really want to know what Unity's terms are for developing under Unity.
Does Unity own your game?
I mean,
question.
that's worth your time.
Yeah.
Right. And yes, I can only imagine what the Unity terms are.
They're not bad.
They're probably not bad, but they're probably long. I guess is what I meant. But that's crucial, right? I mean, if I'm going to use the tool to develop, I'd like to make sure that I've got a piece of it. I think it's friendly. I don't know, but I think it's fairly friendly to the developer. But I don't know.
I will say, and this just to cap off the question a little bit, is with Unity, if you agree to the Unity terms of service, you are agreeing that you will not use Unity to create nuclear weapons.
Oh,
just making sure you're aware of that. So
yeah, some are out. I see some people that are out. There might be another. There's always the Unreal Engine. I think Unreal, maybe it's a nuclear weapon.
It still can't make nuclear weapons with Unreal. Trust me, I've read them.
What else? Quake C? Can I do it in Quake C?
So you had a question, yes?
So I've seen a lot of people talking about some of the newer Disney films, how they're live-action, versions of older movies, talking about how that's a way for Disney to kind of renew their ownership of those characters.
Sort of.
You want right because you said this is kind of your area. Do you think that those kind of predictions? Do you think that that's true? And do you have any opinions on the way that Disney has been keeping ownership of characters
So I'll repeat the question while you think about that. So the question is, people have been looking at Disney releasing live action versions of older animated films, and the prevailing theory is that Disney is doing this in part to play on nostalgia, obviously, but also to extend their copyright and the characters and their ownership of the characters. So how much credence how much legal backing is there behind that theory, right?
So this, I call this evergreening, right? And we see this in all different types of, technically anything of the previous. So let's take our Steamboat Willie, who is now going to be free here shortly, right? The original,
Free Willy,
right? I think there's somewhere where there's actually a countdown clock where someone's going to produce some art based on, regardless of how many different variations of Mickey Mouse, that one will be in the public domain. I think the problem becomes is it will, using the mud analogy, it does make it a little bit fuzzier, right? So I can only take the stuff from the old stuff, but I can't take anything from the new, right? And so where does that line kind of edge one way or another with the, I don't know if Mulan, it's probably not old enough, right? Cinderella or something that's out there in the public domain.
Snow White is one of the people keep an eye on.
I think you could be careful. The key here, though, is even being careful, you might still get a letter, right? And so then the question becomes is, what do you do when you get a letter from Disney? I think that's, and this is where it actually, I shed some tears for the kind of independent creator, because just leverage can cause problems. But technically, you're probably in the right. Unfortunately, it might give some fuzzy space. There are some public interest groups that are pushing to try to make sure that these things become available and used by everyone else. So I think there is some credence to it. I think, quite frankly, Disney's just lazy. I think that's bigger. I think this is a really crude comment on our kind of content creation universe now. Is IP evergreening is like lazy man's ability to kind of create new stuff.
I will say I prefer the new Spider-Man to any Oscar bait that's come out recently.
Oh, that's fair enough. But it's an astute question, and I can only imagine creators are going to be trying to dance in this space over the next couple of years, because a lot of Disney characters, the old original sets are going to, because we're not going to get any more extensions to copyright.
Says you.
I think we are done.
I think the political will to do that has shifted enough.
So it'll be interesting to see what happens when Goofy's free. I don't know. Any Goofy fans out here? Yeah, there we go. Who else, right? But Catwoman would be our Goofy fan. Dogs, cats.
Well, what do you think, Sam?
I think so. Just in terms of like the black letter law, when something hits the public domain, that thing is free to use. Now, Winnie the Pooh, just a couple days ago, hit the public domain. So anything.
Partially.
Well, the original story, the stories, the setting, the characters, the artwork. If you can find it in that book, it is free for you to use. Now, later stories by the same author are not. Tigger came out like 2 years later. No Tigger for a couple of years. The Disney version with the red shirt is drawn just so. No, that's
right.
Now, insofar as it's based on the original book, the story in the book becomes free for you to use and do what you want with. But whatever Disney added to it later is Disney's for whatever length of copyright is still on that. I don't know or care at the moment how long that's going to last. But so, you can do Cinderella because Cinderella is an old fairy tale and it was the public domain when Walt did it back whenever. Snow White.
Our good buddy Walt.
You're in first names. I'm still Mr. Disney, but that's just me.
The Frog Prince, all this stuff. You can go and take, find those fairy tales from a couple hundred years ago and use those. You don't get to do Bibbidi Bobbidi Boo. You don't get to do One Day My Prince Will Come. You don't get to draw the evil stepmother looking like that. But you can do as long as you're not copying what someone else did, you can take these characters that exist and these stories that exist and go crazy with them.
So what essentially that means is we need you specifically to take Winnie the Pooh, the story, and need it to be a ferocious grizzly Pooh. And do that because it's completely different. I believe in you. Good luck, Godspeed. May
That's
the
a
force be with
real-
you always. Yes.
So kind of reiterate, it's almost like how the story of Romeo and Juliet.
Mm-hmm.
You can take that story and make like something like West Side Story.
Yeah.
Take the original concept, alter it. But like you can't take West Side Story's perspective and then alter it some more. Or have that.
Right. And it's something
So
like
to repeat that question, it's basically you can take story of Romeo and Juliet, create West Side Story, but then you can't take West Side Story and create West Side Story without a license.
It
West Side Story
it becomes
2.
tough to say, like,
Yeah.
what's the spacing? I mean, so it could even be that you take Winnie the. I hate to put Winnie the Pooh on you. This is a real burden for you.
Winnie the Pooh is you.
Are you okay? And the problem is you to then get a copyright on it. You've got to make, and I don't know if the ferociousness is enough of what they call a modicum of creativity to be a protectable derivative work. And so when I think about a Romeo Juliet story, it's so crowded that space of a storyline. You probably have to do something fairly dramatic to get it off that arc or spectrum.
Winnie the Pooh and Juliet.
Oh, Winnie the Pooh and Tigger. I never knew.
Oh, not Tigger. Not Tigger. That's
Not
still
Tigger, yeah.
copyright.
No. Oh, sorry. Okay, not
Don't
Tigger.
do it.
Cinderella and Juliet.
But you're on it. It just it does gets cloudy and it gets tough.
I've been seeing that hand consistently back there. Don't worry, everybody else. I'm seeing all of them too. Don't worry.
I'm actually really excited. I'm taking a law school class on just video games next semester.
That's awesome. What school?
Georgetown.
Nice.
Yeah. My question is specifically about the international legal components of video.
Oh God.
Oh boy.
So if you can speak to what are kind of like the legal implications for video game developers, either whether you're a small developer or like a big company like Nintendo, when it comes to like international trade or when you develop a game in the States and then someone in like the UK is playing it, what do you have to do to look up for it?
Yeah. So the question is, keeping in mind that we are in a digital space, what's the implications of international jurisdictions on and international law for U.S. based or non-U.S. based, but having significant U.S. presence, game studios all the way from indie all the way through AAA and publishers, and that's a big question. And there's a lot of different ways we can answer it. So I'm going to challenge everybody up here to focus on that question because that could be a whole panel.
So what I think it's interesting in that getting any type of form protection is really expensive.
Yeah, it is.
And so if I ever
Except
have
in trademarks is affordable.
trademark can be affordable, although if you really are going to go get it
ham
in
with it,
China
yeah.
and everywhere, it's going to be difficult. One of the either beauties or flaws of the video game space is that most of the distributors are US based. Apple, Steam. I mean, maybe I'm saying bad words in a MAGFest, these kind of centralized.
Xbox Game Pass.
But the beauty,
Yeah,
the
Microsoft.
quote beauty of those is that U.S. protection is going to give you that shelf space if someone decides to make the Winnie the Pooh, Ferocious Bear, Killer 2.0 game.
Yeah, that one.
Right, exactly that
They're
one.
making it right there.
And there's the one they're selling in the U.S. and then there's the one they make in India that they want to sell in India. I don't know, but my gut is that to hit the U.S. market, they're going to need to use Steam or one of these distributing, and so you can leverage the U.S. protection to get an international arm on it because of the ubiquity of it. But I'd be interested in the trade because I have to say it's interesting trademark side because there's some abilities to get trademarks for like EU mark, etc. But if you want to hit places like China, India, those are separate applications and they're not cheap I say not cheap,
right.
Thousands of dollars to have to navigate. And if you're some small company, the idea that I need trademark protection in China might be the last thing you're thinking of. But I'll just tell you, I've had clients before. If you get even slightly successful, there's someone filing for a trademark exactly like yours in China. And then they're like, well, what do we do?
Right.
And I'm like, well, now we've got to hire a Chinese attorney. And just because of translation, et cetera, it's
tough.
insanely expensive.
Yeah.
So I'd be interested in what your guys' thoughts of how.
And to kind of piggyback on that, you hit the nail on the head. A lot of stuff runs through the United States, which is dope for everyone in this room. to be very clear. Unless you flew in from Canada, good luck. But that's really great to have that. For example, I do work with several international studios, and one of them hired me to do, frankly, some DMCA takedowns on Google Play because Chinese, perfect nail in the head. Chinese studio had ripped their entire game and uploaded a copy straight to Google Play.
I've had to deal with that myself.
Yeah, and so because Google Play goes through the United States, I was able to use the DMCA, which was an amazing tool for that, and it was resolved pretty quickly. So the answer is, as you move to international scopes, which you are once you publish a game, like immediately, it's terrifying. Here we go again. Talk to a lawyer. And we can help you navigate that kind of thing, even if it's to say, don't worry about that right now. Like, please, God, don't. But oftentimes we can work with international counsel and stuff like that. And I know both of our firms have access to that kind of stuff too.
Yeah.
But not him. So.
No, we don't.
Yeah,
You don't want
it
to
comes
talk
up
about
sometimes. I actually have one client. They do a lot of simulation games, which are pretty big in the European market. Project High Rise is a game one of my clients made. You're building a giant high-rise building, and they're still doing some decent business in Europe. And we looked into it. Do we want to extend the trademark protection for your marks into the EU? There's a pretty easy way to do it. But they looked at the cost, like, you know what? Nah, we're on Steam. That's fine.
Right.
And that pretty much just what you said. You can do all that. And we did, for them, had to take down a Chinese knockoff. And it was just straight rip off. And we're like, all right, well, we have, Google Play is right here. They're based in the US. We send the DMCA, and it got dealt with pretty quickly.
This is the positive side. You can be on the negative side where you're the one getting the
but
letter.
Right.
I don't think any of us are licensed in foreign countries, so we're really
Not yet.
go for it.
Oh, no, I'm not going to do it.
Not really competent to speak on many issues of, or pretty much any issues dealing
Right.
with foreign law.
So, like, for example, when I'm doing takedowns for Among Us, who I've done work for in the past, that's Innersloth becomes a party of three. So they do a lot of stuff with other people. They send in and say, hey, take down this, this, and this, and this. And even though it's international, I can usually take care of it because it has a nexus in the United States, or at least the platform does, so it's subject to those laws. That's a long way of answering your question. Hopefully we did. Your head thing is very shiny.
It is very shiny. I like it.
I had another one. Yes.
Okay, so this might be complicated, but I'll try to simplify it.
Okay, good luck. Godspeed.
I am a solo indie developer, and I've made a bunch of stuff. I haven't trademarked my game yet, but I've got all the assets for it, made all the code base for it, and then I followed the instructions to make an LLC.
Right.
Who do I talk to about getting that out of my name and into my LLC's name? Is it a lawyer, an accountant? Can I just do that myself? I haven't been able to find anything about transferring ownership other than like a domain name.
Yeah. So
Yes, and yes.
For YouTube, real quick, the question is: I've done a lot of stuff for my studio, and now I have created the entity, the company, to house that stuff. How do I get stuff from me to company? And
Yeah, it's actually I do it pretty simply. There might be other ways, but typically all you really need to do is you're setting up your company.
this is not specific advice, by the way.
As you're setting up your company, you
Your
have
name
to
is again. We can fill it in.
typically you make a capital contribution into the company. Basically, what's your buy-in in exchange for company ownership? And if it's a crap ton of copyrights, then it's a crap ton of copyrights, and there you go. And you just note, you have the page of listing all the company assets that you're putting in, and it can even be like assets to XYZ game.
So I think this is where if you're at the stage where this is worth doing, I would probably hire an attorney to draft that transfer agreement.
definitely.
And my gut is they probably would also maybe register some copyrights to make some really nice commodifications of the things you're transferring over.
Potentially.
But I do think the question's a great one because I think this probably happens a lot where you're basically on your own. I don't have time to LLC. I'm creating stuff. And then you're now at this stage of, oh, wait a minute. Like this might actually do something.
Right.
Then I think it is worth doing the LLC and transferring it all over and probably paying $1,000, I don't know, $500, $1,000, whatever, to get it done.
Not much.
So to get it done right.
Yeah, and
It's just a quick, easy transfer.
yeah,
And here's my capital contribution, listing, and you sign it and you're done. And
if,
depending on what state you're in, it might be more complicated than that. But
right, and worst
shouldn't
case
be
scenario, it really turns into, we draft a quick assignment, something, and take care of it. It's one of the most basic things that we do. So, yeah,
But I do
totally
understand the
doable.
oddity of because it does seem weird, because the thing is you're transferring a bunch of intangible stuff. It's not like you're giving a bunch of doodads and you're putting them in the business's facility. It's like things in your head, and you're like, okay, I don't understand. I'm going to transfer these between two entities, right? But you all
Like Johnny Mnemonic.
That's right,
You've seen that movie. Yeah, follow up.
It was really weird just because it was a single member LLC, so everything else was just going through me. Like my taxes go through me. So
Everything goes through you.
Yeah, I know.
Yeah,
Yep.
makes
It's
sense.
weird.
So,
I know.
hold on, I'll get back to you in just 1 second. Yes, buddy.
Kind of a, not lame, but kind of normal question. Each of your favorite laws and your least favorite.
Oh, I love this. So the question is, what is
Favorite laws?
each of your favorite laws and your least favorite laws? Are you ready for this one?
no.
That's
Okay, I can tell you what my. I got a
You've
couple.
answered this before?
I've answered this every day.
Does he come to all of the panels and
and
throws
ask
these
about,
up?
ask about the ferocious.
So
Winnie
he
the Pooh
does
thing.
this to make you look good and make us look bad? Is that the
Great.
deal?
I'll pay you later. I'm kidding. So funny story. When I did my Reddit AMA, this was like the #1 most upvoted question, and it had nothing to do with what I was talking about. So my favorite law is that in Virginia, unless it has been literally repealed in the last 6 months, which I don't think it is, in Virginia, it is illegal to deface a milk carton. Yeah. So you tear apart that milk carton. That, my friend, is a class 3 misdemeanor. You're in trouble, Buster. That's my favorite law.
Why is that? Just so you can tell people that they.
So back in the day when I was at University of Richmond, I had an internship and I was working for one of the nicest prosecutors I've ever met. They never actually went after anybody for like stupid things. They only went after like murderers. And so one of the officers literally wrote a ticket for this. And we threw it out, but we spent half a day chuckling about it.
That's crazy.
It was amazing. And then I would say, honestly, a lot of my least favorite laws are ones that restrict civil liberties in some way or are based in systemic racism, which is a very broad statement, but there's enough of them on the books in every single state that I can't name all of them. So that's my, I hate those.
I can kind of give an answer. At least one law I really like is in Illinois, we have a Biometric Information Privacy Act, which covers.
Jeez.
Yeah. It's, privacy law is getting big, but we have a thing that covers, fingerprints, retinal scans, face geometry scans. And you have to, if you're taking these things, you have to go through a lot of procedures and permissions and whatnot. Or you get sued, and not only do you not have to prove damages, like, yeah, we screwed up, but what's it to you? Okay, give me $1,000.
Yeah.
You can opt to not take actual damages. Just give me $1,000 for every violation. And also provision for possible attorney's fees. So if you can't afford to sue over this, that's okay. If you win, the other side might have to pay your legal bills instead. So it's a thing I follow. It's kind of new. The courts are just now dealing with a lot of issues, but it's something I've definitely been following for years now. Least favorite law, because courts also make laws, qualified immunity.
That one sucks.
It's really bad.
Man, we had like same vein.
Really?
Yeah.
So mine's a lame.
That's the worst thing.
I'll do a lame one. This will be lame. It won't be as earth-shattering. The law I don't like, it's to this earlier discussion, is this idea that I can get copyright protection for things that just have a modicum of creativity. I think we need a higher bar to get copyright protection, because I think we need bigger space between protectable works of expression.
That's an unpopular opinion.
It depends on which side you're on. I think it's but this is just something to me in the patent space. We have this requirement for these big jumps. We call it non-obviousness. Not only do you have to have something that's new, but it's something that's not obvious. I think that copyright law should have something fairly similar to that. It turns out there was really old case that dealt with carnival posters. And there was this question at the Supreme Court as to whether commercial art could be protectable. And the Supreme Court decides that it is protectable. And when they do that decision, they say, we're not going to make any artistic determinations. There just needs to be a modicum of creativity. I like more than modicums of creativity. My creativity is modicum of creativity, but I like bigger jumps.
I was going to say, who out here can identify what a modicum of creativity is? Nobody raise your hand because you're lying.
That's right. So,
I will say one other law I really don't like, more on topic, is the one that made copyright, gave you the extra 20 years of copyright to everything.
Yeah.
I wish we should go back to the 1910 copyright duration of 28 years. Then you have to renew for another 28 years if it's worth it to you.
Yeah.
And maybe make it a lot easier
With reversion rights, yeah.
and fewer penalties for screwing up, because part of the issue was people were doing it wrong, like a little bit wrong.
Mm-hmm.
You forget to check this box and boom, you screwed yourself out of your copyright forever.
Yeah.
So maybe make it a little bit easier and less draconian, but I still think that's way better than 95 years or life plus 70.
Yeah.
Is insane.
and yeah, that's a good point. I should probably give an on-topic answer there. It's hard for me to identify.
look, you guys care about society, etc.
We care about
I'm a
people.
lame IP professor. I've played my role. So
But you're our lame IP professor. No, I will say for me, it's kind of hard to identify a law that I don't like off the top of my head. And the reason is because we are trained to get you the best outcome we can within the system that we're provided. And so I can say, yeah, that kind of sucks, but hey, we got this option to take care of. Like, for example, one of the biggest problems that I run into is when I have a client who is going through a DMCA issue, whether the person countering or filing the takedown. If there's a counterclaim filed, all you can do is sue to keep the content down. So there's certain loopholes that we've developed to make lawsuits affordable instead of filing like a $50,000 suit in federal court. And so we find ways around stuff. But yeah, it's hard. So
Yeah, there are so many issues where, like, I don't care what the answer is. Just tell me what the answer is, so I can tell my clients what to do or not.
exactly.
Like,
So.
there was a Supreme Court case a couple years ago about like timing of copyright registration, when you're allowed to sue and when you have to vis-a-vis when you file the copyright. I don't care. Like, I think there's a right answer based on how I read the statute. I think, and the Supreme Court went along with it without any input from me. But like, if they went the other way, I don't care. Just tell me what to do, so I can tell you what to do, so you don't have to be in a lawsuit that goes up to the Supreme Court.
Right, exactly. So, all right. Yes, sir.
So is there a certain point where a non-compete can be so aggressive
Yes.
that it becomes illegal and that they have to commit to compromise, for example, when it affects your separation from company options?
So the first part of that question is really easy to answer, so I'll repeat it real quick. Yeah, I'm going to repeat it. So the question is there a certain point where a non-competition clause, a non-compete agreement, something like that becomes so aggressive that it's unenforceable, that it's effectively illegal upon signing or voidable? And
Yes.
the answer is candidly yes. When you get to the point where first of all, it's a contract of adhesion. If you don't have the opportunity to negotiate that contract, then that's a problem from the get-go. But it really kind of sometimes depends on state law. I know California is really great in terms of favoring the employee or the worker or the other party, the signatory party, in terms of whether a non-compete is enforceable. They have very specific geographic restrictions and subject matter restrictions, stuff like that. So, yes.
And Illinois actually just the start of the year enacted a new, it was passed last year, but now like non-competes for employees who make less than $45,000 are illegal. Now it's employees, not contractors, but and that amount is set to go up over the course of several years. So a few years, $50,000 or less, illegal to have a non-compete. But they're also, even otherwise, we do look at this because we don't like that. We want you to go and work. And if you can't do any job, you're trained to do whatever. If you can't do that, that's a big problem for society. We don't like them. We'll enforce them in certain circumstances, but every state, I'm going to hazard a guess, has a developed body of law as to when we're going to say that's not all right.
But it is going to vary. So
will vary,
Illinois, I'll just say Virginia, you can get a little bit stronger of a non-compete in Virginia.
Yeah,
We can start kind of picking our politics of the states. If I'm in Texas, I can get a very strong non-compete. But there is eventually a breaking point with these in a sense of their geographic scope, their length of time, their scope of work you're denied to do. I do think it's a good question because has to be something. I'm just thinking the indie developer, you're someone who's doing it in your off time, or you're thinking of a new game when you're working on a different game with your current employer.
Yeah, you're in Blizzard Q&A or something, and
Yeah, there we go.
you're working a QA job, and so but the reason you work for Blizzard is because you're passionate about video games. You wanted to have a video game job. Hey,
There
oh
it
my
is.
God,
There's the cash grab.
there you go. And so you
That's my 6-month subscription right there. What new
God.
trinket do I get?
So you work in the QA job, but you want to stay close. So you want to work on your own game, perhaps. And so what is an enforceable non-compete for Blizzard? Well, here's it's kind of a squirrely way to say it is, even if it's in Illinois, there's certain ways around even illegal non-compete stuff. So if somebody says this is an illegal non-compete, there's ways to say, okay, well, sure, my non-compete agreement with you is illegal. You're free to compete, but you can't use any of the information that you got from us as part of that. And they can make it so expensive for you to defend that you just have to go away.
So I do think that this is something I've seen before where unfortunately someone comes up with a really neat idea and a group of them are working on it after hours or something. And if they haven't navigated this, it's all hindsight's 2020. I think it's something to think about. I mean, if you work in the video game space and you're deciding to make a different video, then I would
Or
go
even the music space,
or
too.
music space,
Yeah.
something that's around the same space. I think that's worth talking to an attorney. If you really think you're going to go for it and you've got something good, because I would be really worried about getting locked up
Right.
with some kind of a employment agreement that's just going to make it a mess
Yeah.
when you guys come up with something really cool and you're ready to leave, and then it's like, oh crap.
Oh no!
Yeah, two things. I just kind of piggyback on that. I want to say real quick. One, if you do have a job like that, you're working Blizzard QA or whatever, or whatever, make sure you read the contract you signed. Like some companies, I don't know Blizzard or anybody else, what kind of moonlighting options are there? Is it like anything you make at all, we own? That might be enforceable or might not, but they're going to fight you for it.
Yeah.
Almost certainly. Sometimes they'll say, okay, on your own time, not using company resources, that's fine. Okay, great. Then don't use your company computer.
It's always
Like,
something to think about.
you
Don't
know,
use your work email. Don't
Figure,
use the
figure it
machine.
out.
Yeah.
Read what's there and make sure you know what it is, and then abide by that. The second thing, relatedly, if it's more like your buddy or you're getting an indie team together, figure this out first. What do we want to do, and who's allowed to use the stuff we make, and what are we doing with it, and what are we not allowed to do, and figure it out. And I was at a music law conference many years ago, and yeah, I know.
I love it. Oh, it's just gonna be going.
And someone said, speaking of like bands forming, get all your agreements, figure everything out when you are happy and hungry. You're
Contracts save friendships.
you're happy because you have this great idea. We're going to make this game in this case, and we're going to do it. It's going to be really fun. We're looking forward to it. And hungry because we haven't made a dime on this, and we need to buy groceries, but we can't.
Yep.
There's no money. We're not looking at any money because I assure you, when a publisher comes along and says, "Hey, here's $500,000 to help make your game," suddenly I did so much more work than you did,
I did everything.
and you are not pulling your weight. I deserve 60% of it.
I'm seeing a lot of that with NFT projects right now. It's a lot. It's
Let's not even
wild.
go there.
But the
I
so
did have those penguins.
those penguins.
I mean, damn it.
So we have officially 4 minutes left. Technically, we have 14 minutes left. So I want to do a quick lightning round to make sure we can kind of like do bang, 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 bang. So who has a question left? Everybody raise your hands if you have a question. 1, 2, 3, 4, 5. You got another question? Save it. Hold on. You're really inquisitive. I like you. So 5. Okay, let's go across the room. Lightning round.
Real quick.
I have an idea for a character. I've looked at them on the patent and trademark website to see if the names are available and that kind of thing. It looks like it's clear. What should I do to make sure?
Is this a hypothetical question or an actual question?
When I say it's an answer,
It's a hypothetical.
It's a hypothetical question. So the question,
Either way, my answer is hire a lawyer.
yeah, the answer, honestly, clear. I hate to say this, but if you're doing a clearance on your own, it's tough for us to put our seal of approval on that because we've spent years doing that stuff and we know where we've made mistakes.
Yeah.
So
If you can do your own, pick like 2 search engines, put the name in. Go on the Patent Trademark Office test search, put the name in, see what comes up. If it's the same kind of project, similar goods or services for similar marks, stop. If not, then come talk to me and I'll run a really big in-depth search for you.
Yeah.
So you can do the quick knockout yourself, but to really get in the thick of it, the weeds, you want someone who knows what he's doing.
My comment would be, how wed are you to the name? If you're not that wed to the name, I would do the search. You feel good about it, go forward. If it turns out I bump into someone else, now Bob's named Jim. Like, I mean, if it's something you really care about, then I might spend the money. I'm a little bit of a different ilk on clearance searches. I don't think, I feel like usually the good clients know their markets. If you're not doing the research to make sure that people won't be confused about the character name, I'd say you're doing a bad job of developing a game, because the hope is your game's better than everybody else's game. You don't want them confused with your game.
Yep.
But I have seen it where people don't do the work, the non-law work.
They're so passionate they don't invest in the time.
Right.
So yeah, always happy to chat. Like I said before, we offer free consults if you're just curious about what it looks like.
I don't offer free.
You don't offer anything. Why are you up? No, just kidding.
It's a very good, because I wanted to come to MAGFest. I've got music rhythm games. I've got to go be bad at here real quick.
All right, so going across this way, yes.
So DraftKings says that they're
Oh, God.
not a gambling company because their game is a game of skill, but it involves putting up money and looking to win money.
Yeah, DraftKings is lying.
Yeah, probably. Okay.
Oh, that's recorded. My bad.
I actually used to work with someone who knew gambling law front and back, center.
Let's repeat it real quick.
Yeah,
Actually, the
go
question
ahead.
is whether or not DraftKings is lying about whether or not they're a game of chance or skill, and whether or not they're actually gambling.
So basically, every state has its own gambling laws, but basically, you need some kind of chance. So one way you get around gambling laws is no, it's a game of skill. No, they might be wrong, but that's one way to do it. You need some kind of consideration. What are you putting up?
Right.
Like, I'm putting in money, I'm putting in whatever, and some kind of prize, some expected gain. If any of those, again, speaking very broadly, consult a local lawyer who knows gambling law in your jurisdiction. But basically, if one of those things isn't there, then you're not gambling. And a lot of what people will try to do is say, no, this is a game of skill. Like,
It's the most common way
Yeah.
to do it.
I mean, I think if I was going to get a game in that space, this is where I'd be like, hire a lawyer.
Yeah.
Like big time. Like if
That's
somebody,
2 in a row.
I mean, that would even more so than the characters.
Oh, yeah,
if someone
no.
said, "Hey,
Do
we're gonna
not
send
run
me
afoul of
cash
the
and we're gonna
gambling
make it,"
board.
I would be worried about that.
Thank you. 10 minutes left. All right.
do not run afoul of the state gambling board.
Yeah,
don't do it.
Don't do it. Gambling, you will get destroyed.
How are your knees?
Yeah. Oh man, that's the mob. You're referring to the mob. I was talking about a government agency. Jesus
So you're
Christ.
saying that there's a difference between the gambling board and well,
Yeah, that's fair.
right,
Going
who's
across
next?
this way. Yes.
I was gonna ask how you guys end up practicing law in this space. Like, did you kind of fall into it, or did you say, I like video games, I want to do video game law,
Yeah.
and take specific steps?
Yeah. Go ahead.
Okay, I'll try to condense this. Started off my first year of law school, the summer after it. I had a friend who made an indie game, and it got ripped off wholesale by a little company in Vietnam, and they couldn't do anything about it. So what do? I don't know, but it kind of got me into the idea of what can you do in copyright and everything. I was lucky. I did have a a video game law seminar, which was really fun, and I took. I also, Suzanne.
Yep.
A good friend of ours who is currently working at Epic
awesome.
in-house counsel. She's wonderful. She was in law school with me, and she was like, yeah, she was a 1L, I was a 3L. And she's like, I'm going to be video game lawyer. I'm going to do this, and this, and this. And I'm like, that's really cool. And then when I graduated and couldn't find a job, I'm like, well, what the heck am I going to do? Maybe I could start going to some of these video game. Maybe I could do something with this. And really, Suzanne got me into it. Like, she inspired me to do that. And it was part of, I do like video games. And I really like this stuff. And I'm happy to help people. Also, I don't have a job. Let me try to have my shingle and pay rent.
Yeah. When I was in law school, I went to law school for criminal law and I went to law school for intellectual property law. And the reason I did that is because I wanted to be in intellectual property law because I was an actor before I was a lawyer. So I paid for law school through acting, which was awesome.
Oh, wow.
Yeah. And I got an IMDb.
I'll check you out.
Yeah, do it. And so I thoroughly enjoyed law school. I got out of law school really young and said, okay, well, I got to figure this out. So I also took criminal defense law just so I could pay the bills while I was building a practice. I started working at an intellectual property boutique immediately. And I was lucky. I got so much experience with the entire realm of intellectual property protection and enforcement. But I hated the firm I was working at, and hopefully they're not watching YouTube. And so I put up my own shingle, and one of my best friends since I was 14 was a very successful Twitch partner. And he said, hey, my Miami lawyer's charging me $5,000 a month. Facebook has told me that you're a lawyer now. Can you do this? And I said, yeah, I got IP law, I got business law, and I also used to play Halo professionally. And so I was like, you know what, let's do it. I learned a lot about music law very quickly.
Music law.
Yeah, and I was thrust into a bunch of panels. There's another attorney in the space. His name's Ryan Morrison, and my buddy said, I need you to be Ryan Morrison, but cheaper and younger. And I said,
Ryan heard this story?
That's why he hired me. And then I went to work for Ryan Morrison for a while, and now I'm at Premac Rogers, loving what I do. So it's actually incredible. My goal, honestly, at my firm is to help train the next crop of video game lawyers, because there are not many of us, and it's an open space, and so it's absolutely fun. So
to me, I think it's
Cheaper
about
and
the entrepreneurial kind of aspects of these individuals is amazing, and I think part of it's going to be
Also just luck.
part of it's going to be
Blind
creating
luck.
the business model that fits. I mean, I think that's one of the things that I always hate to see. There's so many people that need legal services. It's the underserved middle. I know this sounds. Those who are really poor actually can get some legal services, not in the realm we're talking about, and those who are rich, but those in the middle can't afford legal services. I'm not going to get on this, but wills, like basic legal services. I think the next evolution is going to be those who understand how to create a monetization model.
Right.
That can serve those individuals well, but where it's amicable on both sides, right? The attorney can make the money that they need to make, but also whoever it is can get the services they need. Right. And I think if you talk to them a little bit more, you'll probably find that their models, their billing models, are just different than the traditional old school, I do an hour of work, you pay an hourly rate.
Yeah.
It's my gut.
I will say that both Sam and I'll speak for you on this because I know I can, is our goal is to hit and take care of that middle, make sure that everybody has access to affordable legal services, especially in this space. Yeah. Now, we love having the big clients. Don't get me wrong.
I'm happy to have your money.
Yeah.
As much as I can get.
But we also want to make sure that we offer affordable stuff. So.
Yeah. And like I said, I do typically, charge by the hour, although really it's, I'll round down a lot of stuff.
Yeah, exactly.
if I like you and you're not making nuisance of yourself. But like,
if you tell them jokes, if you entertain them.
But, I can offer, like half off my usual rate.
Right.
If you can't afford my usual rate, that's fine.
We'd rather not though, but we can do it.
But I'll say that
Because you need to get this done right.
Right, but the price of an attorney is there actually for a reason. That is, if you can't afford an attorney, I think that you need to kind of rethink where you are in your project and what attention it needs. Not that I'm saying it's a bad project, but it's not a project that commercialization is the path. And I think it's hard for artists to divorce away from that, right? Like they love their work, they think it's great. I mean, there's some people, it's a great pet project. It's a lot of fun. It's not worth paying $500,000. I mean, I don't know if that's whatever. I'm good.
500,000 or 500
No,
or
500 or 1,000.
Okay, thank God. I was like,
My project's only 500 and about.
I don't.
So I do. This would be my other. I think so. When people bemoan the cost of any service, actually, quite frankly, it does create a friction that weeds out those who don't need to go down that.
Exactly.
If that makes any sense.
Well put.
Not to disabuse anyone of their life's dream.
We had at least 2 more over here. Oh yeah, first, and now I'm gonna do the red last. Yes. Oh, same question.
Go for it.
So I actually have a question regarding with more games getting scams of, let's say, actors and stuff and taking their likenesses.
Oh yeah.
I was just wondering if y'all knew of like any legislation brought about from like people who would take their take the assets for the game, say like Fortnite, like Dwayne Johnson stuff, and like do any other product, like do an animation or something using those assets that had those actors' likenesses.
Yeah. So there's a couple of things there, and I want to unpack that. So one was you see likeness law of actors, individuals, famous people, celebrities, etc., or not famous people, Joe Schmo from Reddit. And then that is being embodied in a game. So first of all, how does that come about? And then where does that likeness go? Say if you wanted to be Dwayne "The Rock" Johnson from Jumanji as a cosplay or something, or on OnlyFans. So that kind of stuff. Does that kind of summarize your question?
Sort of mainly if like someone takes the files of the game.
Oh, somebody actually uses the underlying files.
And they like to make an animation.
Yeah, so if somebody takes the underlying files and uses that and makes an animation, that's a problem.
That's 2 lawsuits.
That's at least 2. That's a copyright lawsuit and a likeness lawsuit. And now, if you get the license to do it, then you're square. But at its core, what you are describing is, as we say, illegal.
Legals. You might be civilly liable for what you've done.
It's illegal.
I say
Probably
illegality
no
for
jail
murder,
time,
etc.
but a lot of money damages.
There we go. Fair enough.
You gonna get sued, is what we say.
Yeah.
So great question. You gonna get sued. And guy in the red, and then we'll come back. Trust me. I just want to make sure we get somebody else's question too. Go, yeah, bud.
Yep.
Sora was in Smash. Like, I want to know what happened behind closed doors to make that.
We will never know.
Right.
What
We will never know publicly on a panel. So Sora in Smash, what happened behind closed doors to make that happen? And the answer
I want to know.
is a license.
That's the short answer.
But basically, they went through a lot of negotiation. I actually can talk a little bit about this.
Oh, cool.
There was a lot of negotiation, and it's something that everyone had wanted to do for a while. There was a lot of fan support behind it.
Smash. Okay, now,
Yeah.
okay, now the old man is finally caught up to this.
Welcome to the panel.
Okay, there we go.
But
if it doesn't float up my Twitter top 20, I don't know. That's the only way I keep
Gotta get
up
on
with current
TikTok for you
trends,
page.
Trends here.
But the community really wanted it to happen, and there was interest from both sides. It's just they couldn't make the money work, and finally, the community there was enough. All right, well, we need to make a big splash. Everybody's depressed from COVID. Let's make it happen. And that's effectively how it ended up happening. So, yeah, that's that. And finally, you had one more question. I'll let you have it.
Since you said you like me, so of course I'll try to make my next one. This like me. So what happens if you actually committed yourself to a law firm that actually left you more legally vulnerable than you thought?
Oh.
What is the options you have at that point?
So the question is, if you've committed to a law firm that's left you more legally vulnerable than you'd hoped, what options do you have? I'll be honest with you. I'm going to hesitate to answer that just because I don't ever like to say, I know there are lawyers that don't do a great job. And I've been on the receiving end of fixing some of those mistakes. You do have legal options. What I would recommend at that point is talking to your particular state's bar association, describing what happened, and seeing if that's something you could talk about. Because we do have responsibility and stuff. So.
Okay,
And we have to stop now. So
we gotta wrap it up.
Wrap it up.
Cool. Yeah, happy to chat. So.
Look at that.
Thank
Wrap
you
it
all
up.
so much. You can find us on socials.